Okay, I hope everybody can hear me okay. Welcome to today's webinar. For those that don't know me, my name is John Ridgway. I'm the Head of Legal Services for Pacific Legal Network, and we're delighted to be able to introduce you to John Ioannou, who is one of my fellow principals here in the Australian legal business of Macpherson Kelley. John is a leading tax lawyer. He's talking today on the ATO and its treatment of expats. He's very well qualified to do that. He is the national head of tax in Australia for our business, and he has more than 20 years experience in this area. And despite having more than 20 years experience in that area, John remains an interesting person and a good bloke, and he has promised us all, particularly me today, to make tax exciting. For many of our clients, today's presentation is particularly relevant to them and to their management in a personal context, and I think for businesses which have expats in it throughout the Pacific and across Asia, it's also very important in a business context for that business as well. So as you may have just seen the message, if you have any questions, please put it on the chat. The team will be fielding those questions. I'm very much looking forward to hearing what John has to say in this very, very exciting realm of tax. And John, handing over to you. Good luck and thanks for your contribution for your time today. Thank you.
Absolute pleasure. Thank you, John. I'll do my best to make this interesting and succinct. As John has mentioned, I'm going to talk to you today about the tax office and its treatment of expats. I've put together a bit of an overview. I mean, this is a topic that you could spend days on, but I don't want anybody to lose consciousness. So I'm going to keep it short and sharp to about 25 minutes and highlight probably some of the issues that we're seeing a lot more of, as well as flagging some upcoming themes. But certainly the issue of residency and non-residency is becoming more and more pronounced. Largely because the world's becoming a much smaller place. People can more readily travel and work remotely, and that raises relevantly for me a lot of interesting tax issues. But more and more, we're being asked to give advice to people who are inbound, and I probably can't shy away from the fact that outside of America, Australia has the next most aggressive tax system on the planet. So before you decide to return to Australia, it is really sensible to get some advice and make sure that when you land and take up residency or retake residency, that you do that with an eyes wide opened basis. So the topics that I do want to raise are relevant to those people who are coming to Australia on a regular basis, as the slide deck suggests, or if you're not getting here regularly, have interests here that you're managing from abroad. Or again, if you decide that you've had enough of travelling and you want to come back to Australia, what should you be doing in respect of wealth that you've accumulated whilst offshore? Because there's definitely a right way to bring it and there's a wrong way. So technically, I will just do a brush up on the residency rules and largely do a little bit of myth busting there. Some of the things that do occur when you become an Australian tax resident, as well as flagging some proposed changes to the way we tax capital gains tax events for non-residents in respect of real property. The myth of the 183-day rule. I spend a fair bit of time explaining to people the way our residency tests operate. Um, at the moment, Australia does not have a bright line test. So simply focusing on not being here for 183 days of itself isn't enough to give you comfort that you won't become an Australian resident. So the takeout point here is that the 183-day rule only really works in conjunction with you having, if you are an Australian resident, previously, having properly cut ties when exiting Australia, or the alternative, if you are inbound, still being able to show the Commissioner of Tax that you have a residence elsewhere in the country. Well, I should say in the planet. Um, but there's actually 4 tests at the moment. Being ordinarily resides in Australia, which is relevant if you're currently an Australian resident and you're looking to exit. If you're domiciled in Australia, which in plain terms means if you were born in Australia, there's a presumption that you are an Australian resident unless you can prove your case. The 183-day test, which again is rebuttable if you are able to show that A, you don't have an intention to take up residency here, and B, more importantly, that you have a permanent residence elsewhere, and the Commonwealth superannuation test. So again, that's probably more relevant for people who have worked in Australia, participated in particular Commonwealth superannuation schemes. Once you're a member of one of those schemes, the other 3 tests don't in fact matter. But in taking advice on residency, again, it's highlighting to people that the 183-day test isn't the be-all and end-all. There's 4 tests, and until the law changes, it's a matter of turning our minds to all 4 of them. Noting that the threshold is you have to satisfy the commissioner rather than tax lawyers or accountants. And like all decisions or discretions in my world, being tax, they're viewed with the benefit of hindsight. What are the things that we look for when we're trying to prove the case that residence is elsewhere on the planet? Physical presence, so how many days you're over there as opposed to here. Intention and purpose, ideally not self-serving statements, but more being able to garner third-party evidence of intention and purpose. Location of family, so where spouses are, where kids are, that's not necessarily determinative. There are particular cultures where it's quite common for example, men to stay in their country to deal with business interests and to send spouses with their kids to Australia, primarily to educate them. So whilst location of family is important, we've had lots of success stories where we certainly haven't lost our case because of it. Business and employment ties, maintenance of location of assets and social and living arrangements. Again, because of the breadth of the factors the Commissioner takes into account, determining residency can be difficult. And it's why, I think it was in the 21 budget, they did announce legislative change to introduce a bright line test to try and simplify residency, particularly for individuals, but that has not become law yet. So we're still dealing with all of these factors in addition to the number of days that you might find yourself here. But to drill down on some of these issues from a practical perspective, and these are things that I've extracted from advices that we've given to clients. So when particularly you're looking to leave Australia, so in arriving in Australia, or you could probably see it in the inverse, but certainly short-term indices of a permanent exit is certainly telling your family and friends of your intentions, as well as your business associates. And I should say that the tax office, when it comes to the crunch, is quite happy to talk to business associates and friends to garner this evidence. From a medium-term perspective, you should certainly think in terms of relinquishing your lease, or if you live in a property that you own, making that available to others for use while you're away. When you're coming back to Australia, using temporary accommodation, not having personal effects here, ceasing to hold bank accounts, although this isn't critical, but certainly informing government departments, not only the tax office, but certainly the Electoral Commission, Department of Transport, are good indicators of your intention to permanently exit Australia. And from a long-term perspective, again, you can see that ceasing to maintain things like health insurance here, not frequently returning, when you do, staying with friends or family, or short-term accommodation. Not doing any one of these particular things isn't fatal, but anything that the commissioner can hang his hat on in trying to argue that you are a resident, they will use. So I sort of advise clients that one or two things doesn't matter, but you do need a consistent theme across different facets in order to maintain a position of non-residency. And having inconsistent positions in particular areas isn't fatal, but certainly can make the job a little bit harder. In becoming an Australian tax resident, or returning as a tax resident, the second line is probably the most important. You start to be assessed on your worldwide income, which is the starting position. Leaving aside any real property that you may already own here in Australia, all other forms of assets, when they come into the Australian tax net, as an oversimplification, take a taxing point equal to their market value at the date of becoming resident. So it is important, if you're contemplating coming back to Australia, that you have robust market valuations of all non-real property assets that you own, because you will only be subject to Australian tax on gains that exceed that market value. Structures are a little bit more complex. This really does become a matter of obtaining advice before you come to Australia. So to keep it very simple, trusts and companies that do not own or operate businesses offshore, but instead house, I'll say, passive wealth or investments, ideally ought to be collapsed before you come to Australia. Our regime in respect of non-resident trusts under the Transfer All Trust Rules and Section 99B, and for companies controlled foreign corporations, essentially look to pierce those entities and will look to assess an Australian resident on an ongoing basis on those amounts, notwithstanding they're still retained in structures. That can surprise a lot of people. And in addition to being subject to tax on amounts that you probably otherwise don't think you should be, the compliance costs in respect of those regimes can be quite exorbitant. So it is recommended that you at least take advice before becoming a resident so you know what you're signing up to. But if it's possible to collapse them tax efficiently offshore, to do that and resettle those amounts into Australian structures. Foreign companies that operate businesses are a little bit simpler to deal with. As the slide suggests, where you have businesses operating in locally incorporated companies that aren't interacting with Australia, we tend to leave those alone on the basis that they're seen as active income. So there won't be any attribution under Australian tax regime, provided there's no goods and services being provided back to Australian residents. If you do have companies or incorporated in listed countries, and there's 7 of them, the only I'll say Pacific one that might be relevant is Japan and New Zealand, because they have similar tax regimes to Australia. Even if those companies hold passive income, Australia won't look to attribute any of that. But again, it's important to get advice before returning to our shores, because normally there's a straightforward way to reorganise affairs to avoid those attribution regimes. Foreign Australian property, what the current state of play is. Fair to say the Australian tax regime hasn't really favoured foreign investment insofar as Australian real property has been concerned. So for a little while now, the general discount, which gives you an effective after tax of 75%, which means a flat rate of tax of about 25%. That no longer applies for CGT assets when they're held by non-residents, and that's been the case since 2012. We also abolished the main residence exemption for non-residents since 2017. We currently, and for a long time, have had a foreign resident CGT withholding regime, and there has been some changes to that, which I'll flag on the next slide as part of my closing comments. There are some limited exceptions which most, well, even conveyancers in Australian property are now familiar with, but there's a process that you can apply to the tax office in order to obtain clearance certificates or declarations to avoid having to remit the CGT withholding. For those who have invested in Australia or interacted with the idea of investing in Australia, you would be familiar with the requirement to make a FIRB application before investing. It's probably a little less known that the tax office has what I would call a sister requirement. So in addition to obtaining FIRB approval in respect of acquiring Australian property, you actually also require approval from the tax office, and that's required before a binding contract is entered into. Unsurprisingly, there are fees in addition to the FIRB fees that are required to be paid, and which are dictated by the type of property that's to be acquired. And in addition to FIRB approval, the tax office also maintains a register of foreign ownership of Australian assets, which is required to be updated. Well, it should be unsurprising in the world of information and technology. There are ongoing registration requirements in respect of ownership of Australian assets by non-residents that span not only Commonwealth jurisdiction, but also state-based jurisdictions. Because if you weren't aware already, certainly each of the territories and states in Australia impose differing amounts of stamp duty, land taxes and vacancy taxes where real property is owned by a non-resident. So again, it's familiarising yourself with these issues before entering into a binding contract. And some proposed changes, which we are yet to see the detail on, although there's a couple of consultation papers that are floating around that don't shed any more light than what's already highlighted on the slide. But in our last budget, there's certainly moves to strengthen the foreign resident CGT regime. The first couple of points are really aimed at the mining and resources sector in Australia. There were some inconsistencies as to what, from a Commonwealth law perspective, taxable Australian real property actually comprised when looking at corporates and how they held their mining tenements and fixtures and fittings. So there'll be a tightening up of that definition to essentially broaden what constitutes taxable Australian real property. Excuse me. And that will really bring it in line with what a lot of the stamp duty laws already provide for in each of the states. So in addition to real property being included in the test, it'll be extended to fixtures, fittings, as well as chattels that can be easily removed from the land. Excuse me. Which from a common law perspective, most property lawyers will tell you they are not fixtures as per property law definitions. That's correct for property law purposes, but that will no longer be correct for income tax purposes in the context of these rules, and hasn't been that case for stamp duty purposes for a little while. The bigger one, and it's probably the one that's put tax lawyers as well as M&A lawyers on guard, are some new reporting requirements in respect of M&A transactions, where they are introducing a regime where there will be a mandatory notification to the ATO by foreign residents who dispose of their shares and other membership interests that exceed $20 million prior to the transaction being executed. This is an unusual one. I have quite strong views on it, which I won't share, but I could give you the heads up that they are not positive. It's probably curious to understand the ATO's reasoning behind introducing this framework, primarily because for most non-residents who are disposing of shares in companies, Australian companies that don't hold taxable Australian real property, they're not subject to tax here in Australia. So we're all wondering why there's a regime being introduced to report on it. We are still yet to see the detail of it, but we're curious to see how it is that we can engage with the tax office on a M&A deal in respect of a transaction that hasn't been signed, sealed, and delivered. Most of the reporting requirements, leaving aside property acquisitions to the tax office, happen on a retrospective basis. And the tax office, like other government bodies, while they proclaim to have expedient service times, in practice often don't. So I can see quite a lot of frustration bubbling to the surface if we do end up seeing this regime enacted in a way that, you know, will ultimately, I think, hinder commercial transactions rather than facilitate them. And for those who already have experience in the foreign residence CGT withholding regime, from 1 July 25, we will see an increase of the rate from 12.5% to 15%, and they will have removed the land value threshold, which currently is 750,000, but that'll be reduced to nil. They are the proposed changes. I just realised I haven't updated my my contact slide, but just to cover off on a question that's popped up, whether you should declare to the tax office that you're coming back or waiting until you return before doing that. Well, ideally, you should be alerting the tax office that you are becoming a resident. For those who were previously residents and have continued to file non-resident tax returns, which is normally because there would still be income being derived here, might be rent or interest. Alerting the tax office would simply be filing a resident tax return in the subsequent year. For first timers, as part of becoming an Australian resident, you will be required to apply for a tax file number, which will be the prompt to start to file a tax return. Ideally, you should be seeing a tax advisor once you've determined that you're returning to Australia and you'll be based here permanently. If you haven't done it before arriving, I would strongly recommend within 3 to 6 months of arriving. Do have another question, whether Australian tax laws allow the Australian government to impose tax exemptions on companies wishing to do foreign direct investments in Australia. There are certainly, although I've probably highlighted all of the difficulties with foreign investment in Australia, I should say there is a broad framework of structures and opportunities provided by the government to allow foreign investment in a way that's taxed efficiently from the foreign investor's perspective. But I think there's that would be undertaken on a case-by-case basis. I think there's a lot more we could do to become a bit more competitive, but certainly there are ways to do it efficiently. Thank you, Viv, as you've suggested. Happy to take questions, or you can email me directly on ji@mk.com.au.
I just thought I'd put that in the chat.
Thank you.
We've got one more question. Do the FIRB rules apply to Australian citizens but is an income tax non-resident?
No.
That's come through on the, okay, easy, no.
Yeah, so that it's actually a really good question. Being an Australian citizen does switch off a lot of the measures aimed at non-residents. So you can be an Australian citizen, and where you are a non-resident for Australian tax purposes, you are still treated essentially as a resident for a lot of the measures. The clear carve out to that though is the main residence exemption as well as CGT discount. So there are some issues in having bought or acquired assets as an Australian citizen, ceasing to be resident but retaining those assets, and then onshoring again. That period of non-residency, importantly, isn't ignored for those two purposes.
Okay. Are there any more questions? Just a couple of minutes if anybody. There you go. We've got one. You got that, John?
Yep. Residency, when does being resident apply for overseas, if not resident in the foreign country? Yeah, it is a really good question, and I know some of the cases. Some of the cases highlight, for example, Australian residents who have done everything to cut ties with Australia on exit, but in going overseas haven't successfully planted enough roots in another jurisdiction to qualify as a resident and still being hauled back into the Australian tax net. Again, because of one of those other tests, being domiciled, which is once you're born here, you're almost stuck with it, or not being able to show that you reside elsewhere. So certainly there is an art form in knowing what needs to be done in order to properly cease residency for Australian tax purposes. What it takes to take up residency somewhere else, or we do have lots of clients in situations where they are in fact resident of two countries and then understanding what those implications are. Ideally doing that in a country where Australia has a double tax treaty to avoid double tax, or if you're in a country where we don't have a double tax treaty, understanding that and normally taking steps to reorganise your affairs to avoid double taxation.
Okay, I hope that answers the question, James. I think that's a good time to wrap up. And so if anybody does have questions, please feel free to email John. And thank you very much, John, for a really interesting presentation, which really highlights the complexity of our Australian taxation system.
Thank you.
All right. Thanks, everybody. Please feel free to contact John with any more questions.